All right, hello all. Good afternoon, good morning, good evening, I guess, depending on where you're joining us from. My name is Mark Butcha. I am a partner with Thompson Hine's Antitrust Practice Group. And I'm joined today by my partners Jen Roach and Caitlin Thomas, who are also members of our antitrust practice here at the firm. Welcome to today's webinar. This is the seventh in a series of webinars examining what the shift in presidential power could mean for the country. Today, we're going to examine the latest shifts at the FTC and Department of Justice's Antitrust Division and what the next 4 years of antitrust enforcement may have in store. But before we begin, just a few housekeeping matters. Today's program is being recorded, and we will send you a link within the next few days. This presentation is intended for general information of individuals and organizations on matters of current interests. The thoughts and opinions expressed today are those of the individual panel members only and do not necessarily reflect the opinions of our clients, our employers, or of Thompson Hine. The content should not be taken as legal advice, as the views expressed here are for informational purposes only. If you have questions during the webinar, feel free to use the question box, which you should see located in the control panel on the right side of your screen. We'll answer as many of the questions as we can at the end of the webinar, or maybe as we see them come through. We'll see how that goes. CLE credit for today's webinar is pending. Please be sure to complete the verification of attendance survey. The link to the survey is posted in the chat. We will also paste the link in the chat at the end of the program. I will announce the attendance tracking code at the end of the program as well. In the handout panel, you can also download a copy of the PowerPoint slides and the bios of our speakers today. So again, thank you for your interest. And if you have questions as we go along, please, again, use the question box. So with that, I see people still joining a little bit, but we may as well get started here. So again, good afternoon, good morning, good evening. We today are going to talk about some antitrust developments, I guess, as they are, changes that are happening in the administration and in the antitrust agencies, FTC and DOJ. Sort of where the enforcement may be going, where it looks like it has gone already, and where it may be going over the next few years, including whether the change in administration is really going to affect antitrust enforcement all that much, and if so, how. We're going to talk specifically about merger enforcement and the new HSR rules that have been put into place and that went into effect about a month ago. I'm going to talk about that here shortly. Jen is going to talk a little bit about the competitor collaboration guidelines, which are no more as of just a short while ago, and what that means going forward. And she's also going to talk about price discrimination under the Robinson-Patman Act, which I think many thought was no more at one point in time, but perhaps now is back, or maybe there's some kind of mixture of the two. And then Caitlin is going to talk on the continuing enforcement of the antitrust laws in labor markets, which really picked up steam during the last administration and may be continuing going forward. And she's also going to talk a little bit about climate cartels and antitrust laws being applied to ESG initiatives and how they might apply, and whether we're going to be looking at some enforcement or investigation going forward. So the first thing I'm going to talk about today is Biden to Trump. Is this just a vibe shift? Is it something else? It's fair to say, I think, that this is not a traditional transition from a sort of ordinary Democratic administration to an ordinary Republican one. There are very different things happening culturally than maybe in a traditional Republican administration. And at the same time, there's some continuity being signaled, at least from the agencies, about what they're focusing on in terms of enforcement and how they're going to enforce the antitrust laws, perhaps more than one might think in a traditional shift from a Democratic to a Republican administration. But there are some shifts in enforcement focus, to be sure, and we're going to talk about those here as well. So at the top, just a few shifts in tone and focus. I'm sure everyone who's following the news has noticed a lot of shifts in tone and focus over the past couple of months with the new administration, or the past 6 weeks or so. One is that diversity, equity, inclusion initiatives have been a focus of the administration writ large, and the antitrust agencies are no exception to that. The quote I have on the slide here, DEI is a scourge on our institutions, is a quote from the FTC's current chair. and tells you where the FTC stands on the issue of DEI. It sort of stands a piece with the rest of the administration and could be using the antitrust laws to perhaps investigate or enforce and antitrust laws and consumer protection laws against DEI initiatives. Big tech was certainly no stranger to inquiries, investigations, and lawsuits under the Biden administration, and there's no indication that under the Trump administration this is going to change. There are many pending lawsuits, and I have seen no indication that the Trump administration is going to back off any of those at this point. But in addition to that, the administration, including the FTC, is focusing on what it calls censorship by some of these platforms. And the censorship, in their view, could be viewed as facilitating collusion, or that collusion is facilitating censorship in the social media arena. Artificial intelligence, under the last administration, there was a lot of focus on how and whether, and not really whether, but how to regulate the artificial intelligence industry as it sort of became more prevalent after the release of ChatGPT in 2022. The new administration has at least signaled a different approach from the regulatory approach of the Biden administration to a more generally hands-off approach in removing the barriers to AI companies, and to ensure that in the administration's view, the U.S. remains at the forefront of AI innovation. And lastly, this is just as another data point in the sort of vibe shift, so to speak. The American Bar Association antitrust section has been traditionally a place where the FTC and DOJ and the defense bar and the plaintiffs bar will come together, discuss antitrust issues, and you're at conferences and see what the enforcers are thinking, that kind of thing. And the FTC chair has recently issued a letter refusing to allow political appointees at the FTC from participating in ABA activities. This is in some ways different from the prior administration because it's focused on what it calls the ABA's leftist advocacy, but also is a little different because, or is a little bit the same. Lena Khan, when she was appointed chair of the FTC, did a similar thing in terms of highlighting the supposed coziness between enforcers and the defense bar. So in that way, this is not all that unusual, and we'll see how it plays out, but certainly the focus on the ABA specifically, and with the sort of heightened rhetoric, is something to look out for. So the FTC itself has been under fire. The FTC, as some of you may know, but I'll just repeat here, shares concurrent jurisdiction with DOJ to enforce the antitrust laws. And there have been challenges to the FTC's constitutionality as an independent agency. And there have been calls by some in the administration and elsewhere for the FTC's antitrust authority to be merged with that of the Department of Justice. There's currently a bill in Congress called the One Agency Act that would consolidate enforcement with the DOJ. There's also an executive order from the administration that asserts presidential control over the entire executive branch, which would include, quote, so-called independent regulatory agencies, such as the FTC. And so the FTC has a lot more White House oversight at this moment than perhaps it would have in the past. And its status as an independent agency and its status as an antitrust enforcer is not in doubt at this point, but is certainly being questioned by the administration and on Capitol Hill. I mentioned at the outset a little bit of maybe continuity, maybe more than some might believe. Just wanted to point out a couple of things. One is that the current vice president actually supported Biden's FTC chair, Lena Khan, and her efforts to enforce the antitrust laws. Recently, the FTC reaffirmed, and DOJ reaffirmed, the merger guidelines that were issued by the Biden administration, which were widely criticized in conservative circles at the time, but have now been reaffirmed by both antitrust agencies. And a new HSR rule has gone into effect as scheduled. On February 10th, it went into effect, which creates much more onerous reporting requirements for deals subject to HSR. Caitlin will talk about this more later, but there's a new joint labor task force that was initiated by the FTC. And of course, as I touched on, the big tech remains a focus of enforcement. So I'll talk a little bit more about merger enforcement now. There have actually been two merger cases already brought by the Trump administration, one by DOJ and one by the FTC. In the DOJ case, it involved what DOJ alleges are the second and third largest providers of wireless local area network technology. And the FTC's case involves the medical device coatings industry and what it calls the two largest manufacturers of medical device coatings with a combined market share above 50%. These are, I would characterize as very traditional sort of merger cases based on traditional kind of antitrust analysis involving players who are at the top of industries or near the top in terms of market share. So there's nothing really unusual about these cases. I would call them business as usual. But other than that, we don't have much indication of whether merger enforcement is going to continue as it did under the past administration, where the agencies were much more aggressive in their litigation tactics. DOJ pretty famously refused to actually reach any settlements during the last administration and would insist on litigating any cases where it thought there was an issue. We will see whether, I think folks generally expect there will be more remedies and settlements in merger cases under the new administration, but there have not been any just yet. So I'm going to talk for the balance of my time here about the HSR rule that's gone into effect. I'm going to talk about this at a somewhat high level. We did do a webinar in December that dives into detail about this if you're interested, but I will for now take the last 8 minutes of my time here to talk about this at a high level. So if you're not familiar with HSR is an act that requires parties to any kind of acquisition that meets a certain threshold. Right now, the size of the transaction threshold is $126.4 million, to file a form and certain information and documents and then observe a 30-day waiting period before closing a transaction. When you file HSR, there are three things that could happen. One, the waiting period expires, you can close your transaction. Two is that there's an investigation open by DOJ or FTC. And three, the DOJ or FTC files a suit to enjoin the transaction. Usually the third thing doesn't happen until the second thing happens, but it could happen earlier at the end of the 30-day period. So what has not changed in the new HSR rules? Reportability. If the deal was reportable before, it's still reportable. If the deal was not reportable before, it's still reportable. So nothing changed about what deals were subject to the HSR Act. The jurisdictional thresholds will still change annually. The parties that are required to make an HSR filing are still the same as they were before. The 30-day waiting period I mentioned before is still the same. And there's nothing about the substantive antitrust law that is used to analyze a transaction that has changed either. That still generally is Section 7 of the Clayton Act, which prohibits acquisitions that may substantially lessen competition. So that's what hasn't changed. What has changed? And the short answer is a lot. But the new HSR rule went into effect a month ago. It was approved unanimously by the FTC, including by the two Republican commissioners who are the current chair of the FTC and one of the two Republican commissioners on the FTC. That's important because I think some folks believed that when the new HSR rule was finally passed, there would be litigation and that it could be struck down. But the 5-0 vote and reaffirming of the HSR rules by the Republican commissioners make clear that the rules are going to be in effect for a long time, I would think. The FTC estimates that the added time and burden of preparing an HSR filing is now going to be more than 2 times what it was under the old rules. And in particular, transactions that have product overlaps or supply relationships between the parties will require more information than they did before, and more than those, and even now under the new rule, more information than those deals that do not have those qualities. So virtually all the information that was required before is still required. There are some additional terms though. One thing to note at the outset is that filing on a letter of intent is no longer permissible. The material terms of an agreement have to be in place. So you could file potentially on what's actually termed a letter of intent, but it has to have a lot more detail in it than it did under the old rules. And beyond that, more is what the slide says. More narrative submissions, more documents, more data, and more disclosures are going to be required. I'll touch on some of those here in just a moment. Under the old rule, this is just an illustration to show you some of the differences between the old rule and the new rule. Under the old rule, you had to to describe the transaction, and it was usually a pretty bare bones description that said, voting securities of this amount are being acquired. The business, in one sentence, the business operates in this industry and expects to close on or about this date. Under the new rule, the narrative submissions are much more substantial. You have to describe the business operations and the strategic rationale for the deal, and describe categories of products and services that are provided by the companies, including whether they compete and how they compete. And you have to describe supply and licensing relationships and provide citations to documents when you're making pronouncements in the submission. So more documents. If you've ever done HSR filing before, you know that collecting and reviewing item 4C documents is the most onerous and important part of the form. 4C documents are documents prepared by or for an officer of either company for the purpose of evaluating the transaction with respect to competition-related matters. For example, markets, market shares, competitors, potential for growth, expansion into new products, or geographic market territories. The new HSR filing requirements for item 4C require more than just officers and directors. So you have to collect not only from officers and directors, but also from a supervisory deal team lead, which could be the person who's not an officer, but is responsible for spearheading the transaction and organizing the transaction and evaluating the transaction. Drafts under the old rules they did not need to be submitted with the HSR filing unless they were submitted to the entire board, at which point the FTC considered those to be no longer drafts. Now documents are no longer drafts if they go to any board member, not just the entire board. So if there's a CEO, for example, who is working on a transaction and evaluating it and is working on drafts of a presentation to give to the entire board, but the draft never goes to the whole board, but it's in the CEO's files, it now has to be submitted with the HSR filing. And in addition, certain ordinary course documents, mainly I'll just refer to them as strategic business plans and similar type documents, have to be submitted with the HSR filing if they relate to the overlapping products or services. Ordinarily, these would have been documents that would be submitted in a voluntary investigation during the HSR waiting period, and now the new HSR requirements are simply moving this sort of up in the process. So if you have a deal with an overlap, you've got to submit these strategic business plans with the HSR filing rather than waiting to see whether the agencies have questions. More data, more information is required for deals that have either horizontal product or service overlaps or vertical supply or licensing relationships. So the overlapping products or services must be identified, and revenue, customer, and product development data needs to be submitted in those instances. Similarly, where you have to identify products or services sold to or purchased from the target or its competitors and provide customer and supplier data when there is a a vertical supply or licensing relationship. More disclosures are required. Currently, certain minority investors have to be disclosed in the HSR filing, but they are usually only of the UPE and acquiring entity, and now that will include all covered entities. So if the UPE has 4 companies between the UPE and the acquiring entity, now the minority investors of all the entities in between have to be disclosed, not just the 2. In addition, officers and directors have to be disclosed in instances where there are product overlaps or supply relationships between the parties. Prior acquisitions had to be disclosed on the HSR form under the old rule by the buyer, and now that's expanded to include the target's prior acquisitions in certain circumstances. On the prior form, whether filings were made in foreign jurisdictions was a voluntary disclosure, and now it's mandatory. And in addition, certain national security related issues require disclosures regarding foreign subsidies from countries of concern, as well as certain information related to defense and intelligence contracts. So what does all this mean at the end of the day? A few practical implications. The timing and burden, there's more information to collect, longer timelines to prepare a filing, so preparing early is important. Training employees on document creation becomes even more important because more documents need to be submitted with the filing, including strategic business plans and similar ordinary course type documents. So narratives in the HSR form also have to be based on the documents and cited to the documents. So training employees on document creation is important to help focus on the pro-competitive benefits of a deal and to ensure that the story that you would like to tell the agency matches the documents that you've actually created. Planning and preparation early is important. Assessing the risk early is important, and developing a strategy for advocacy is important. One benefit is that with the new HSR form and the new narratives, there is an opportunity at that early stage to put your position forward to the agencies and to get some advocacy in before any questions are asked by the agencies, and sort of tell your story with the HSR filing rather than having to wait until the agencies reach out to you. So that is it for merger enforcement. I am going to now turn it to Jen, who's going to talk about the competitor collaboration guidelines.
Thanks very much, Mark. So I'm not going to bury the lead here, but the competitor collaboration guidelines have already been withdrawn. That was at least the case in December of 2024, after they've been in place for almost a quarter of a century. And we don't know where they're going to go next. So that's sort of the headline here. Let's talk a little bit about what the guidelines are and why they were put in place in the first instance. So the FTC and DOJ promulgated these, the antitrust guidelines for collaborations among competitors. That's the formal title of the document. Mark talked about mergers earlier, but this is really another important area of antitrust enforcement and risk that involves competitor collaborations. And these guidelines are specifically geared towards those types of agreements and collaborations that are outside of the merger context. The agencies recognized that competitors do need to collaborate, sometimes in order to compete more effectively, to fund innovation, perhaps to expand their geographic reach, all things like that, lower costs. All these types of collaborations can be pro-competitive. The exact definition that they have in the guidelines is arrangements between competitors would be agreements between actual or prospective competitors to collaborate on one or more economic activities like research and development, production, marketing, manufacturing, product distribution, sales, or purchasing. Information sharing and trade associations can also take place through competitor collaborations as well. So that's what we're talking about here. A joint venture could be an example of a competitor collaboration. Could change the slide, please. Thanks. So as I mentioned, these were issued in April of 2000. FTC and DOJ recognized that there may be some hesitancy and a perception out there by folks in the market that competitors shouldn't collaborate, or they would run the risk of drawing the ire of the enforcement agencies. So these guidelines were really intended to explain how the agencies would analyze certain antitrust issues that are raised by collaborations among competitors, to tell folks in different industries what the antitrust enforcement policy of the agencies would be regarding competitor collaborations, and then to explain how these collaborations are going to be analyzed, given the fact that there's a wide variety of collaborations and markets within which those collaborations could occur. And the goal was really to help businesses in assessing whether the agencies would challenge a particular collaboration or any agreements that comprise the collaboration. So what do the guidelines cover? General principles for how the agencies are going to evaluate agreements. Things like pro-competitive benefits are discussed in the guidelines, such as efficiency enhancements, complementary participants. So both of these things would be pro-competitive because if you're enhancing efficiency, you're likely to lower costs or create innovation and thereby be pro-competitive, have beneficial effects on the market, and generally likely to have a lower antitrust risk. So the guidelines set out some things that if you were thinking about having some agreements with a competitor that you could rely on, that these would be considered pro-competitive and low-risk activities. The guidelines also discuss anti-competitive harms, which is something that would be more likely to draw the attention of enforcers and create more of an antitrust risk. So in this instance, if you were involved in a collaboration where you had the ability or incentive to profitably raise prices above what you otherwise would be able to do without the agreement, such as by reducing output, reductions of innovation or quality or services, then that would be something that would be considered an anti-competitive harm. So these are just general principles as how the agencies would look at a collaboration. The one thing that's important to note has always been the case, if the agreement was per se illegal, meaning it was designed to fix prices, bid rig, allocate customers, allocate territory, anything like that, that's not going to be, the analysis of the agencies isn't going to change in that respect. They also talked about the second way that agencies would look at agreements, which is under the rule of reason. So if it's not per se, they would conduct a typical rule of reason analysis. Probably the most important thing, though, is that the guidelines created these antitrust safety zones for most folks who are interested in using these guidelines and determining whether they applied to a specific agreement that they would have a competitor. These safety zones were really to give certainty where anti-competitive effects were so unlikely that the agencies would just presume that the collaboration is lawful. So in this instance, what we're really talking about is market participants where their shares of the market collectively would be no more than 20% of the relevant marketplace, where competition might be affected. So if individually they exceed the 20% threshold, or together the collaboration would exceed the 20% threshold, that would be outside of the safety zone. But if you your market share was less than that, then you could be reasonably assured that so long as you weren't engaged in any per se activity that we just discussed, the enforcers would consider your activity low risk, and your collaboration would not meet a threshold that they would consider subject to further investigation. So the next slide, please. Thanks. So 2 months ago, FTC and DOJ's Antitrust Division jointly announced the withdrawal of the collaboration guidelines. The reasoning behind the decision was that the guidelines no longer provide reliable guidance about how enforcers assess the legality of collaborations involving competitors. They noted changes in case law in the intervening 25 years, but didn't point to any specific cases. They also noted that the guidelines rely in part on outdated and withdrawn policy statements, again, without really citing to anything specific. Third, that the guidelines risk creating safe harbors that we just talked about without a basis in any antitrust statutes, that 20% market power threshold. And then finally, they noted that antitrust enforcement going forward would be on a case-by-case basis, depending on the area of competitor collaborations. So there's some speculation about whether these guidelines might be reinstated or new guidelines adopted. The decision at the FTC in favor of dropping the guidelines was 3-2. The 2 dissenting votes were from Republican members or Republican appointees of the committee, one being the new and current chair of the FTC, Andrew Ferguson. Both Mr. Ferguson and Commissioner Holyoke based their dissents on the timing of the FTC and DOJ's decision, that it came after the election and within about 40 days of the inauguration. Chairman Ferguson did express support for review and revision of guidance from time to time, but he said this wasn't the time for these guidelines given the proximity to the election and the inauguration. Commissioner Holyoke noted that the change in the guidelines left businesses grasping in the dark without any guidance on replacement or any indication whether they might be reinstated or replaced in the future. So the jury is still out on this because the newly appointed commissioner who has not yet been confirmed, Mark Meter, it's unclear whether he would vote in favor of reinstatement or not. But right now there are no guidelines. There is no more safe harbor. So whether they're reinstated or not, we do have some hints about enforcement priorities from the current commissioners. As Mark referenced earlier with respect to DEI, the Chairman Ferguson said that he intends the FTC to investigate and prosecute collusion on DEI, ESG, and advertiser boycotts. And this was submitted in a document authored before his confirmation hearings. In addition, whether collaborations between competitors are scrutinized may depend on the industry and market at issue. Each of the two current FTC commissioners appointed by Republicans, as well as appointee Mark Meter, have all said that they support antitrust enforcement actions against big tech. So even if those guidelines aren't still in place, we have some sense of where their investigations and focus might be. All right, next we're going to talk about the Robinson-Patman Act. You can go ahead one slide. Thanks, Mark. So the 1936 amendment to the Clayton Act is the Robinson-Patman Act. It prohibits certain discriminatory pricing practices. The purpose was really to address the concern that powerful suppliers who controlled a lot of resources and goods were providing large chains with more favorable pricing terms, thereby hurting competition and driving mom and pop stores out of business. Section 2A makes it unlawful to discriminate in price between different purchasers of of commodities where its effect is to lessen competition or to injure, destroy, or prevent competition. The RPA also prohibits other practices that involve unequal treatment of purchasers with respect to promotional allowances, the provision of services to customers. And there are some defenses embedded within the statute in Section 2B, things like if the price difference is justified by the costs incurred by the seller, if the lower price is designed to meet a competitor's price, if the goods are perishable, things like that. So this is sort of a basic structure of the Robinson-Patman Act. Most of the action is in Section 2A and Sections 2D and 2E. And as we'll see going forward, that doesn't seem like that's going to change here in the near term. So the two provisions that are most often subject to civil suits and enforcement actions historically have been 2A and 2D and 2E. These are the elements of a 2A claim here. The elements are both pretty similar. The difference being that Section 2A requires an injury to competition, and that's the courts have changed the interpretation of that over time. But one thing that's important to note that is it's not just the price of the good, it also includes any discounts, rebates, or other alterations to the price that may even happen after the fact, after the transaction is completed, that are used to figure out what the price is. So next slide. The 2D and 2E claims have very similar requirements, but here it's really dealing with a situation where the price of the good is effectively reduced for a purchaser if the supplier provides funds to advertise the products, additional services, or things like that that they're not offering to competing customers. One other important thing is that this doesn't apply to services. It literally is only to goods that are sold for resale or consumption in the United States. So not services, which can sometimes be difficult to distinguish depending on what the contract is for and what the product is. Historical enforcement. This is a good segue into where we are right now, I think. 1937 and 1971, the Robinson-Patman Act was enforced very aggressively. There were over 1,100 cases filed during this period. It really peaked in the 1960s. The case law during this period also enabled, that was largely brought by the FTC, enabled the expansion of the injury that needed to be proved to establish a Section 2A violation, and tilted more towards it was just an injury to a competitor, rather than injury to competition as a whole. In 1977, there was a definite shift when antitrust policy became less concerned about protecting small businesses and focused more on consumer welfare in the form of lower prices and increased output. In 1977, DOJ issued a report that was really critical of the FTC's enforcement of the statute, concluding it resulted in higher prices and created inefficiencies in distribution and encouraged price coordination among competitors. The DOJ ultimately recommended that Congress give serious consideration to repealing the statute at that point. It didn't happen. But you can see from the fact that we went from 1,100 complaints filed over roughly the same time period, I guess a little bit more time period, to 6 complaints filed in 1981 to 1996. There were 5 during the Reagan administration and 1 during the Clinton administration. Fast forward until now, there are no complaints filed since 1996 until just about 2 months ago, when 2 complaints were filed by the FTC. So for the longest period of time, everyone thought that enforcement by DOJ and FTC of the Robinson-Patman Act may in fact be dead, but it's not, given the fact that we've had 2 complaints just filed in the last few months here. So the developments in the Biden administration started in 2021 with respect to the Robinson-Patman Act. His executive order on promoting competition in the American economy. After that, a year later, the FTC signaled that it was interested in resuming enforcement of the Robinson-Patman Act. In 2024, the Competition Council that was created by Biden's executive order announced a strike force that was going to be investigating such practices. And in 2022, the FTC had said they were investigating rebates paid by drug manufacturers to pharmacy benefit manufacturers, as those might violate the Robinson-Patman Act. We also had then news that the FTC was investigating both pharmaceutical and beverage industries for possible violations of Robinson-Patman Act. That was made public in 2023 and 2024. Next slide, please. Thanks. Just mentioned that the FTC have filed 2 lawsuits. The first was in December of 2024, the second in January of 2025. The first involved a 2A violation. The most recent is against PepsiCo, filed in the Southern District of New York, and it alleged a disproportionate promotional allowances and services were provided to a large big box retailer, and those violations were under sections 2D and 2E. The allegations are that the Pepsi's conduct harms competition and drives up prices. Unfortunately, we don't know a ton more about this complaint because most of it is redacted at this point. The FTC did put out a summary. You can read some of the allegations of the complaint online, but it is heavily redacted. It's important to note that the FTC voted 3-2 to file both of these suits, and the Republican appointees, including Andrew Ferguson, were the dissenters from the decision to file these lawsuits. Next slide. And here's some language from their dissenting statements. Chairman Ferguson said, "It was the worst case I have seen in my time at the commission," and that the pleadings failed to state a claim and lacked evidence to support allegations. They were very critical of the timing of these lawsuits and the fact that they believe that there was no factual support for the allegations, as well as we talked about the expanding interpretation of competitive injury back between the 30s and the 1970s. They were also keen to focus on the fact that there wasn't a competitive injury that justified the lawsuits against that were brought in December and January. The FTC hasn't dismissed these actions yet. They're still pending, and the decision may be waiting on confirmation of the new appointee to the FTC, who is Mark Meter. And he has actually written in favor of some enforcement of the Robinson-Patman Act. Blanket refusal to enforce the RPA not only offends the rules of law, it throws the baby out with the bathwater and leaves helpless those consumers who are harmed. So there's at least some chance that he could vote to continue with these lawsuits and perhaps pursue others. But next slide, please. There doesn't seem to be a huge appetite for this. It really is uncertain how or if the Robinson-Patman Act will be enforced. Meter hasn't yet been confirmed. And although Commissioner Holyoke and Chairman Ferguson have both acknowledged that they have an obligation to enforce the Robinson-Patman Act, it seems like in the dissenting statements to the two votes on the lawsuits that were filed in December and January, that they really are interested in repudiating any, that they want to leave some room for the FTC to take some actions potentially in certain circumstances where there's evidence of reduced output or other market-wide harms, again, focusing on that competitive injury aspect of the analysis. But it doesn't seem like there is any longer a sort of de facto policy that the Robinson-Patman Act won't be enforced. But it certainly doesn't appear that it will be a significant part of the administration's antitrust enforcement going forward.
All right, you can go to the next slide, please, Mark. So on January 16, 2025, the FTC and DOJ jointly issued antitrust guidelines for business activities affecting workers as implied by the name. The guidelines explain how the FTC and DOJ will assess whether business practices affecting workers violate the antitrust laws. These guidelines replace the 2016 antitrust guidance for human resource professionals that was put in place by the Obama administration and adhered to by the first Trump administration and by the Biden administration. There's a continued focus on no-poach, wage fixing, and information sharing agreements, as well as the FTC's focus on non-compete agreements. Unlike the 2016 HR guidance, which had the support of all 5 FTC commissioners when it was released late in the Obama administration, the new guidelines were supported only by the FTC's 3 Democrats, and the 2 Republicans dissented, similarly to what they did with the competitive collaboration guidelines. Now Chair Ferguson wrote in his dissent that the commission majority, quote, should not replace existing guidelines mere days before they hand over the baton. The Biden-Harris FTC announcing its views on how to comply with the antitrust laws in the future is a senseless waste of commission resources. The Biden-Harris FTC has no future, unquote. Next slide, please. So the guidelines identify a few general principles and enforcement priorities, such as wage fixing and no-poach conspiracies among employers, that are largely consistent with the previous HR guidance. They do carry over some useful guidance on principles likely to persist in the new administration, including that agreements do not need to be explicit or written to violate the antitrust laws, mutual understanding or so-called gentlemen's agreements, just like formal contracts, can violate the antitrust laws. They've also emphasized that the per se and the rule of reason apply to labor market restraints depending on the type of restraint at issue, and that businesses can be competitors for workers even if the businesses provide different products or services. So for example, an airplane manufacturer and their part suppliers may both hire from the same market for engineers, and thus they could be deemed horizontal competitors in the market despite their vertical relationship. The new guidelines also includes a section articulating the principle that antitrust laws apply to agreements that businesses reach with independent contractors. This is new and different from the HR guidance. The guidelines cite the, quote, growth of technology platforms such as smartphone apps, unquote, that enable businesses to use independent contractors rather than employees to match workers who provide labor with consumers seeking their services, and state that these kind of platform businesses are subject to the antitrust laws with respect to both their employees and independent contractors. An agreement between two or more competing platforms to fix compensation of independent contractors offering their services via the platforms may constitute a per se violation of the antitrust laws that exposes them to criminal liability. This was not in the previous HR guidance, and it is completely new to these guidelines. Next, please. So what activities may violate the 2025 guidelines? The guidelines list activities, what they say may constitute antitrust violations. And notably, the guidelines address not only agreements among competing employers, but agreements that employers may have with their own employees. This is a big difference from the 2016 HR guidance, which explicitly disclaimed addressing contracts between an employer and an employee, including non-compete clauses. Also notable is that the guidelines encourage anyone with information about the enlisted activities to report them to the agencies and provide a way to report them. And they do so despite caveats that the activities may or may not constitute an antitrust violation, that nothing in the guidelines should be construed as mandating a particular outcome in any specific case, and that the guidelines do not limit the discretion of any U.S. governmental agency to take any action or not to take action with respect to the matters under its jurisdiction. So these caveats introduce some ambiguity about what the agency believes violate the antitrust laws, while also allowing anyone to report information about potential violations to the agencies. Next slide. So the guidelines now have, we'll say, two categories of agreements that may violate the antitrust laws and potentially trigger criminal or civil liability. And those are agreements among employers and agreements between an employer and employee. So agreements among employers that may violate the antitrust laws include wage fixing and no poach agreements. And this is similar to the 2016 HR guidance, and that the guidelines emphasize that wage poaching and no poach agreements between businesses that compete with each other for employees may violate antitrust laws, even if the agreements did not result in actual harm. And the DOJ may criminally investigate and, where appropriate, bring felony charges against participants in these types of agreements. The guidelines also now appear to open the door to civil enforcement in at least some wage fixing or no poach cases, which had not previously been the case. The guidelines explain that the agencies focus on the substance of the agreements rather than the particular form, so it doesn't need to be called a no poach agreement or wage fixing agreement. Anything that has the form of a no poach or wage fixing agreement could be a potential antitrust violation. The guidelines list examples of wage fixing and no poach agreements, which include agreements to align, stabilize, or coordinate compensation, agreements to set starting points, specific levels, ranges, or ceilings for compensation, agreements to use a benchmark to calculate compensation, agreements not to hire each other's employees, including current, former, or potential employees, agreements not to solicit or cold call each other's employees or otherwise restrict the ability to hire employees, even if a particular agreement does not completely prohibit hiring the other company's workers, and agreements to request permission from another company before trying to hire an employee. Given the past statements and criminal charges by both the Biden administration and the first Trump administration, it seems likely that continued criminal investigations of suspected wage fixing and no poach agreements are to remain the norm, as well as potential civil investigations by the DOJ and FTC. Next, the guidelines have a separate section addressing agreements in the franchise context. The guidelines state that an agreement between a franchisor and franchisee not to compete for workers can be per se unlawful, and a franchisor organizing or enforcing a no poach agreement among franchisees could also violate the antitrust laws. Notably, this franchise-specific section of the guidelines does not mention criminal enforcement, so it's likely to only be civil enforcement. And to date, none of the DOJ's criminal wage fixing or no poach charges have arose in the franchise context. The final agreement among employers that may be a violation of the antitrust laws are sharing information about wages, terms, and conditions of employment. Any type of competitively sensitive information about compensation or other employment information is a potential violation of the antitrust laws. The guidelines tie the potential violation to, quote, when the information exchange has or is likely to have an effect, anti-competitive effect, unquote. This indicates that the agency's intent to approach such information exchanges is probably going to be a civil rule of reason case. The guidelines also emphasize that providing competitively sensitive information through an algorithm or through a third-party tool or product may be unlawful. So this is really focused on tech and artificial intelligence that may potentially allow the exchange of competitively sensitive information. The prior affirmative guidance from the 2016 HR guidance for when an information exchange may be lawful is now omitted in these new guidelines, and instead there's an example of what the agencies view as an unlawful wage information exchange. So this can be a little bit tricky in that there's not a list of lawful activity, and instead you'll just have to figure out what could be unlawful based on examples that are provided by the guidelines. And now that the guidelines include employer-employee agreements that may be unlawful, they specifically call out non-compete clauses. The guidelines state that non-compete clauses decrease competition for workers and also harm competition by preventing other businesses from obtaining enough workers to enter a market, or prevent potential competitors from forming, thereby blocking competitors from competing effectively with the original employer. And this can be a violation of the antitrust laws. The guidelines explain that the agencies may investigate and take action against non-competes and other restraints on worker mobility that limit competition. Other restrictive, exclusionary, or predatory employment conditions may also be considered a violation of the antitrust law. The guidelines include a catch-all category, noting that the agencies may investigate and take action against any restrictive agreements that will impede worker mobility or otherwise undermine competition. There is a list of potentially anti-competitive restrictions in the guidelines, which includes non-disclosure agreements that span such a large scope of information that they function to prevent workers from seeking or accepting other work or starting a business after they leave their jobs. Non-solicitation agreements that are so broad in their prohibition on soliciting former clients or customers that it prevents a worker from seeking or accepting a job or starting a business. Training repayment agreements that function to prevent a worker from working for another firm or starting a business. And exit fee and liquidated damages agreements that require workers to pay a financial penalty for leaving their employer when these agreements would prevent them from working for another firm or starting a business. The guidelines emphasize that the analysis and legality of such a restriction depends on the specific facts and circumstances, indicating that these will be rule of reason cases if a case is brought under these other restraints on worker mobility. Notably, some of the agency's theories in the employer-employee agreement context, such as the non-solicitation, training repayment agreements, are not grounded in or are largely untested under antitrust law, so there is not much precedent in this area, and it's unclear what the theories will be based on violation of the antitrust law for these type of agreements. Next slide. So what is the potential impact of these new guidelines? I think it's important to note that the tone of the guidelines stands in contrast to the 2016 HR guidance. The HR guidance spoke directly to HR professionals and described what conduct created a risk of violating the antitrust laws, focusing on agreements or communications among employers. The 2016 HR guidance also included a question and answer section that allowed HR professionals to understand the boundaries of lawful conduct using real-world examples. However, the new guidelines no longer contain this kind of guidance, instead offering broad statements about what may be unlawful and expanding their coverage to provisions in the employee contracts context. Given that the two Republican commissioners dissented, including the now chair of the FTC, the Trump administration's FTC and Antitrust Division may revise the guidelines or withdraw them entirely and revert to the HR guidance. That has not happened so far, and the dissents from the two Republican commissioners focused on the timing of the guidelines issuance and reiterated rather than the substance of them, and the now chair reiterated in his dissent that, quote, the antitrust laws protect employees from unlawful restraints of the labor markets, unquote. It's also important to keep in mind that the first Trump administration DOJ actively pursued labor market antitrust cases, including bringing the first criminal cases alleging wage fixing and no poach agreements. So even though there were 2 dissents, it's not a given that the second Trump administration will be more lenient on labor market antitrust issues, and recent action by the FTC indicates that it will be. Next slide, please. On February 26, 2025, the FTC announced the formation of a joint labor task force by the Bureaus of Competition, Consumer Protection and Economics, and the Office of Policy Planning, which is aimed at addressing deceptive, unfair, and anti-competitive practices impacting labor markets. The announcement of the Joint Labor Task Force signaled an unexpected continuity with the Biden era's FTC labor enforcement priorities. The FTC announcement of the task force framed labor market concerns as central to its dual mandate to protect people from both deceptive trade practices and unfair methods of competition. The announcement of the task force identified specific enforcement targets, which it explicitly categorized as unfair methods of competition. These include no poach, non-solicitation, and no hire agreements, wage fixing agreements, non-compete agreements, potential collusion on DEI metrics, misleading job advertisements, fraudulent franchise offerings, labor contract termination penalties, harmful occupational licensing requirements, and job scams. Some of these targets, such as misleading job advertisements and misleading franchise offerings, expand the scope of scrutiny beyond competition concerns. So it's yet to be seen how this task force is going to bring cases under, competition and anti-competitive practices when they don't include necessarily competition-related concerns. So what is the impact of the labor market task force going to have? The task force is going to prioritize investigation and prosecution of deceptive, unfair, or anti-competitive labor market conduct. And it states in its announcement of the task force that the FTC bureaus intend to harmonize their methods and procedures for uncovering and investigating deceptive, unfair, anti-competitive labor market conduct, create an information sharing protocol across the bureaus, promote research on harmful labor market conduct, and engage in public outreach on these issues. In deciding to prioritize labor market enforcement, Chair Ferguson marks a notable shift from his previous opposition to the Biden era's FTC's non-compete ban. So it's unclear whether the administration will continue to pursue the non-compete ban or drop the case that is currently on appeal. The FTC's formation of the Joint Task Force indicates that labor market practices, including non-compete and no-poach agreements, will remain a key area of regulatory scrutiny, and that there are likely to continue to be both civil and criminal cases in this area. So antitrust risks, antitrust and ESG, you can, next slide please, Mark. When companies collaborate to implement ESG initiatives, there's risk that the collaboration could be anti-competitive, particularly if it involves competitors and results in decreased outputs, increased prices, or a group boycott in a certain industry. While the Biden administration did not focus on ESG initiatives as a potential antitrust violations, that is likely to change with the current administration. ESG initiatives are likely going to be a target of antitrust enforcement, especially if there's coordination of competitors involved. In November of 2024, 11 Republican state attorneys general filed a federal antitrust lawsuit against the 3 biggest institutional investors in the world, claiming that asset managers engaged in a scheme to pressure coal companies to reduce their output and increase the price of coal, with the goal of reducing greenhouse gas emissions. The plaintiffs in those cases allege that the defendants suppressed coal output through horizontal acquisitions throughout the publicly held coal sector, which allowed the defendants to yield immense influence and lessen competition in the market, and exertion of pressure to reduce production via proxy voting, meetings, and other engagement. The complaint alleges that the firm's collusion and deceptive trade practices to achieve ESG commitments violated Section 1 of the Sherman Act, Section 7 of the Clayton Act, and several state antitrust and consumer protection laws. The states are seeking injunctive relief, civil fines and penalties, and even divestiture to refrain defendants from engaging in further practices. In January, 2 more states led by Republican attorneys generals joined the case, and similarly, members of Congress have called certain ESG collaborations climate cartels. So while these are state attorneys generals that have initiated this antitrust case against ESG collaboratives, it seems likely that the Trump administration, DOJ, and FTC will follow suit. So the impact is important for clients and companies engaged in ESG initiatives. Companies should be mindful of the effect that federal antitrust laws may have on their ability to pursue sustainability objectives that involve collaborations with competitors. It's important to note that so-called social justifications are not a defense to anti-competitive restraints that violate the antitrust laws. Agreements or information sharing among competitors that may affect prices or output risk running afoul of competition law, regardless of the social utility of any shared goals that is motivating that collaboration. Efforts to pursue ESG initiatives without violating antitrust laws are best achieved through unilateral action rather than collaborating, particularly with a competitor. And another way to pursue ESG initiatives without violating the antitrust laws is through collectively petitioning policymakers under the Noor-Pennington doctrine.
Thank you, Caitlin. I think that takes us to the top of the hour, everyone. Thank you all for your interest in attending the webinar today. Our webinar series, Transition, a Presidential Change, continues next week, March 18th at 2 p.m., which will look at the current environment of trade crimes enforcement. Sessions are held at 2 p.m. on Tuesdays. Check your inbox for invitations, and I hope that you can join us. If you're not currently receiving our updates and invitations, we invite you to go to the Thompson Hine website and register to receive mailings. Thank you all for your interest and attending today's webinar. Enjoy the rest of your day.